One of the most Googled topics related to estate planning is what is a living trust. So today we're going to explore this, why you might need it, what it is, and what are some of the benefits and disadvantages of having a living trust. So let's get into it. All right, so a living trust, like I said, it's one of the most Googled topics out there related to estate planning. So you might have heard it called a living trust. You might have heard it called a revocable living trust. Those are both the same thing. All right, so we're going to talk about what it is. We're also going to talk about why you need it. I'm Stuart Green. If you want to stay up to date on the most relevant topics related to estates and trust planning, subscribe to our channel. We're going to talk about kind of the background that leads up to needing this revocable living trust, this trust agreement. All right, so as a means of background, like I just said, why might you need it? All right, so when a person dies, any assets in their individual name have to go through what is called the probate process. That is a government-sanctioned legal process that says your assets have to go through a court-supervised process. There's a judge there who will look at your will, if you have a will. If you don't have a will, then they'll still require an inventory of your assets. Even if you do have a will, you're still going to have to present an inventory of your assets. There's going to be someone who is appointed to have legal authority in this particular role. That's what's called an executor or an administrator, a legal representative who goes through this process on your behalf since you've passed away. All right. So a lot of people want to avoid this probate process. Why do they want to do it? It's costly. Assets can get frozen going through the process. It can be contentious. It involves lawyers. It involves the government, the court system, a judge. It's also a very public process. So anyone can access any of the information, the documents that go through the probate process in your local district court. All right, so if you want to avoid this process, you need to get assets out of your individual name before you pass away. And the way that most people do this is using a living trust or a revocable living trust. So now we're going to talk about what is this trust, this revocable living trust. And then next, we're going to talk about whether or not you need a will or you need a trust, or you might need both. So keep with us. All right, so what is this revocable living trust? It's an agreement. It's a legal document. It's actually an agreement between multiple parties. The person setting it up, that can be called the settlor or the grantor, then also the trustee, and that's the person or persons or even entity that's in charge of managing the assets of the trust and also administering those assets according to the terms of the trust. So what does that really mean? It just means that's the person that's in charge of overseeing the assets and making sure that the beneficiaries of the trust benefit according to the terms of the trust. All right. So let's try to break this down a little bit. With most revocable living trusts, again, with the idea of avoiding probate, most clients are going to set a revocable living trust up for their own benefit, and they're going to name themselves as the trustee. The whole idea here is that you're changing the nature of legal ownership from you as an individual over to the trust. That in itself is enough to avoid the probate process. The idea is that you just change ownership, but you continue to manage the assets because you're the trustee of that trust, and you continue to use those assets the same way because you're the beneficiary. So you still have the same beneficial interest. You still have the responsibility of managing those assets. For all intents and purposes, nothing really changes once you set up this structure, except for the fact that you're no longer owning those assets in your individual name. All right, so that's it. That's really the beauty of it in its simplest terms. Change ownership to be able to avoid probate, because probate's costly. It can take a long time. Assets can get frozen. Use of those assets can get frozen during the probate process. All right, so let's wrap this up, come full circle. Does a person need a will, or do they need a trust, or do they potentially need both? You definitely need a will. And I would say most clients, I advise all clients have a living trust. I'm very trust-based in my approach to estate planning for a variety of different reasons. But ultimately, a living trust still needs a will. So, well, it doesn't need a will. The person setting it up needs both. The reason that I say that, even if you are doing an estate plan to avoid probate, there's still some things you could run into where you still need an executor or a legal representative to be able to transact on your behalf or the behalf of your estate. The reason that you might still need this is because there's final tax returns that are going to have to get filed, and you need someone who has the authority to represent your estate on your behalf when you pass away. File final tax returns. Maybe there is a tax refund that's coming back to you. Maybe the IRS audits the tax return. Maybe they need additional information. Someone has to have the legal authority to discuss that with the IRS. That's going to be your executor. So even if you avoided probate, you still need that person to be able to conduct those affairs. Another thing that may pop up is that there could be some type of dispute regarding your estate. You want to make sure that there's someone there who can transact on behalf of your estate, answer any questions, or represent the estate. Another thing that you want to keep in mind is that, let's just say you pass away in a tragic accident. Maybe it's you get hit in someone runs a red light, they hit you, that's how you pass away from that. It's likely that your family wants to bring a lawsuit against that person who maybe ran the red light, or maybe there's some kind of negligence that involved your passing. You need someone who can bring a lawsuit against that person who led to your death, right? The executor is the person who can do that. If you don't have a will in place that names an executor, then your family or your friends, someone is going to have to go through a legal process, a separate legal process that's going to take more time, it's going to take more money to be able to name someone as a legal representative to be able to bring suit, to file a tax return, to be able to represent you against the IRS, whatever it may be. So go on and do your family a favor. Have a will, even if you have a trust. Don't just do one or the other. If you have a living trust, you still need a will. So the idea there is avoid probate. I highly encourage people to avoid probate. There is a bit of heavy lifting that you have to do going through the implementation process once you actually get the estate plan documents signed. But once you get assets moved over, you're going to avoid probate. But don't forget that you still need a last will and testament.